Thank you very much, Mr. Chairman. Good afternoon to colleague members of the committee. Good afternoon to all those who may be joining us from different locations. I want to begin by reiterating my thanks to everyone who has been a part of this work and a part of this discussion. Colleagues from the Council of Europe, Sir David Simmons and the Law Review Commission, government colleagues in the Ministry of Industry, Innovation, Science and Technology, and others who have been involved in the bill's drafting. I want to thank you, the members of this committee. But in particular on this occasion, I must thank Barbadians. I heard from a young Barbadian this morning as I was on my way here. I must thank Barbadian who came to give evidence to the committee, and I was very much heartened by his engagement and his presentation. I want to thank Barbadians and others who have taken an interest in the legislation and what it means for them, what it means for all of us. It was important for us to facilitate a certain level of understanding of why this legislation is needed and to facilitate a certain level of input from the Barbadian people into its finalization. And so I thank the Senate for allowing me, even after it passed the House, to pause its debate in order for us to be able to fully consider all the ideas and inputs by sending this bill to this committee. I also want to otherwise put this work, Mr. Chairman and colleagues, in context. We have received feedback, and I'm sure this committee has as well, from people who say, on one hand, that the bill goes too far, and those who say it does not go far enough. We've received feedback from those who, on the one hand, are extremely passionate about wanting their data protected, and those who question the very provisions of the bill that are specifically designed and drafted to protect people's data. And so I pause this legislation in order for it to come to committee, to encourage us as Barbadians to reflect on what we want. And I say that with all sincerity, to reflect on what we want and the kind of world we want to live in. And I feel quite heartened and I feel quite privileged that we have the kind of democracy and parliamentary system that allows us to do that. But I say that to suggest that we can determine that we want to fully experience and enjoy all the benefits of technology and living and working and having our being in an online environment, and then pretend that they're not risks and therefore safeguards that must attach. So I fully support the use and the work of bipartisan committees such as this one, Chair, because these matters of security and safety cannot be the subject of political opportunism. Our democracy must finally become more mature than that, and I've been very heartened to see some of the honest conversation that has been taking place. But I have to highlight that data and technology are the new global currency, and they are also at once the new global nuclear weapon. And I do not exaggerate. The scope for harm in the area of data and technology, where there are no borders, where action is often invisible, the scope must be taken in its full perspective. National security councils all over the world, including ours, now realize that they have to contend with this in a way perhaps more than they have to contend with matters of physical security. We have, in a matter of days now, Cricket World Cup starting here, where the world will be in this region and the world will be watching this region. And we have to make sure that we have the wherewithal to be able to respond and to protect our people, to protect our systems, to protect our information, because that information is the currency and equally the weapon that will be used by those who want to harm us. So I am glad that this committee in its bipartisan nature gives an opportunity to all sides to show true, evolved leadership by not deliberately mischaracterizing the intent and likely impact of the law, but by focusing honestly on people's real concerns, many of which are worthy of our reflection. And so again, I thank those people who have brought their concerns to this committee and to our attention. So, Mr. Chairman, I'm not going to attempt to repeat my hours of presentation. First on piloting the bill and then on wrapping up the debate in the House. You have those presentations in your evidence, and in those I speak to each clause and respond to many comments that have been placed at that time in the public domain. All I'm going to seek to do here this afternoon is to clarify a few questions that have come to our attention, to address some concerns, and finally to offer you some suggestions based on my own reflections on this legislation. So I want first to draw our attention to a global example that we've seen recently, and it is a case of Ruby Freeman, case out of the United States, and her daughter, Wandrea Moss. On November 3rd, 2020, Ms. Moss and her mother, Ruby Freeman, sat across from each other in a counting house, began counting the number of mail-in ballots that had come in during the US election due to the COVID-19 pandemic. At the end of that count, the tally showed that Joe Biden had a narrow lead over Trump, less than 15,000 votes across all of Georgia. 3 days later, officials in the state announced an automatic recount that would take place because of the thin margin, and Joe Biden at that time prevailed again. Donald Trump then demanded a second recount, which again affirmed Biden's victory. And in the meantime, Trump and some of his allies began sharing some unproven accusations of election workers allegedly perpetrating fraud. In early December, a month after Election Day, Ms. Moss learned that a video of her and her mother had been circulating online alongside what can only be characterized as outlandish interpretations of what the two women appeared to be doing as they were counting those mail-in ballots. Another video showed Ms. Freeman handing her daughter a small item that was imperceptible on the grainy live stream footage. However, some people online accused the two, these are regular election workers, accused the two of them of exchanging a USB drive, which was allegedly somehow meant to be used to manipulate votes. It turns out that the mother had in that case been passing her daughter some ginger mints. But the conspiracy theory, and I'm sure all of us know of this case, took hold and took off. The following week, the man who served as Trump's personal attorney, Rudy Giuliani, told legislators that a video circulating online showed, quote, Ruby Freeman and Shay Freeman Moss quite obviously surreptitiously passing around USB ports as if they're vials of heroin or cocaine, end quote. Facebook, on email, by phone, supporters of Trump who were disgruntled, convinced that Ms. Freeman and Ms. Moss had orchestrated an election fraud on a scale that was capable of upending the result of a nationwide election, began assaulting them with hateful messages, often with racist overtones. Shortly thereafter, their addresses were posted online. People started appearing in front of their homes, harassing them and their neighbors. Moss had been staying at her grandmother's home, and people also started going there. The result of this was that all of this, as one would expect, took a toll on these women's mental well-being. They had to give up their jobs. They had to move from their homes. They ceased going out in public. As a result of this suit that was brought against Rudy Giuliani and others, he was ordered to pay them $148 million in damages. And the matter has been elevated to criminal proceedings against Trump and others. Now, I start there to put in context the potential damage that we are talking about here. The fact that a video shared online, circulated online, followed by comments and harassment also shared online, destroyed the lives of these two women. And I dare say that what they have lost in terms of their reputation, in terms of their well-being, cannot be recovered, even with $148 million if they were in fact to see any part of that settlement. But I make the point that it was elevated to a criminal matter because I think that in these things, and this is what the legislation tries to bear out, in these things there is a very, very thin line between the civil and the criminal. And it is our estimation, and it is the experience of many people, that these matters begin to trespass, and in fact trespass wholly, in the area of criminal harm, injury, and damage. I also want, though, to put it in further context by addressing addressing the notion, I should say, that anyone who has anything to say in any circumstance that may cause a nuisance or irritation or that we might not like is liable to criminal proceedings under this legislation. I want to highlight, and I only repeat because I have done so in bringing the bill to the House. I believe others have done so. But the use of the word intentionally in the legislation is perhaps one of the most important things that we have to acknowledge. There must be intentionality behind the act in order for it to stand up to the kind of prosecution that the bill contemplates. There's also a certain evidentiary standard on the part of the prosecution that there are more lawyers in here than I've been around in a small room in a long time. So I don't need to tell you that the evidentiary standard is very high. The evidentiary standard that the prosecutor must meet is not just the balance of probabilities. It has to be beyond a reasonable doubt. The defense, the standard for the defense is then the balance of probabilities. And so I start there because, and I'll come back to it later in my presentation, because I want from the outset to dispel the notion that anything that anybody says, no matter the circumstance, no matter the intent, is the subject or is the target of this legislation. That's not the case. I'm sure that everyone in this room has read this bill over and over and over and understand that there must be intentionality. One must seek and one must intend to do harm, or one must intend to act without thought to the falsehood of the allegations being made. And I'll come to that a little bit later. I want very quickly, though, to go through just a few of the comments that have been made in the public domain. Some of the claims, I suppose, I would say, that have been made with respect to the Budapest Convention, the extent to which it has a certain amount of level of rigor, the extent to which it is, whether or not it stands the test of robustness as the convention that we should follow with respect to cybercrime. And so I just want to share a few things with you and with those who might be listening. There has been this claim made that the Budapest Convention on which this legislation is styled or framed is not best in class. The notion that there's a new UN treaty on cybercrime coming and that this legislation and the Budapest Convention are at odds with or incompatible with that UN treaty. That is not the case. And I will tell you for reference that I've had many conversations and consultations, not just with those colleagues from the Council of Europe who work on the Budapest Convention, but also people who are working currently on the UN treaty and who have a perspective on the comparative robustness of the two pieces of work. And I will not venture an opinion myself, but the fact is, and it has been documented, that there's no incompatibility at all. The UN treaty is not even complete. It is projected that it will be finished early August. The UN treaty is likely to be slightly more limited in scope, and in fact, some member states have already expressed concern that it is too limited in scope in many ways. There has been a claim made that the UN treaty will be more robust and more expansive. In fact, the opposite is the case. Nothing in the second protocol to the Budapest Convention will be reflected in the UN treaty. And in fact, the treaty copies the illegal access provisions from the Budapest Convention. And so the treaty in many ways looks at the Budapest Convention for guidance on how it should frame itself. You would be interested to note that since the beginning of the UN treaty discussions, the pace of countries joining and signing on to the Budapest Convention has been, in fact, picking up rapidly. So far from countries feeling as if they should step aside and wait for the UN treaty that is going to be more robust. In fact, countries have, since negotiations started on that treaty, begun signing up, becoming signatory to the Budapest Convention more rapidly. Under the Budapest Convention, you have over 70 countries that are required by law to be your friend, that are required by law to assist in cybercrime matters, and that cannot be understated. I'll say for the information of the committee that Grenada recently joined the Budapest Convention. Over the last month, 3 more countries have signed on and 5 more are expected to sign on before the end of June. So there are now 73 party signatory and 19 that have been invited. And invited simply means that these countries have sent a letter requesting to join, and on that basis have been invited. I also want to highlight something. For those who say that the bill or the convention don't cover this or don't cover that or don't cover another thing. The fact that some things might be missing from the current convention does not put them out of the question. That's why protocols are added often to these kinds of frameworks. The second additional protocol is just that. It gives additionality. It doesn't amend what was there, but it gives additionality. It gives more options. And so this is something that I wanted to make clear because I think we need to be able to put to bed once and for all. We need to be able to clarify that, first of all, cybercrime legislation and the things that present are evolving. And that's one of the reasons there's some things that are noted that will be amended or changed in the schedule by ministerial order, because we fully expect that, weeks, months, years from now, the technology that we'll have to be concerned about will have changed drastically. So that addresses the issue of compatibility with the UN treaty and this notion that the UN treaty is somehow superior. In fact, it is not. It is more limited, and countries, notwithstanding that it is coming by August, remain committed to signing up to the Budapest Convention. I also need to turn quickly to this question of ethical hacking. and it has come up with respect to the claim is being made that the bill should make provisions for this thing that is being loosely framed as something called ethical hacking. And I think that we have to be careful about how we define these things. So I will say, and we are aware, that there's some discussion in various countries of finding a way to permit different kinds of access for a public service purpose. In every country that I'm aware of, that remains unresolved. And why? It remains unresolved because it is very hard to distinguish this activity from a crime. And so, one thing that the law must be is certain. And so, and let me explain for those who may not have been previously aware of what I'm talking about. There is those who have made certain inputs to this conversation have suggested that this practice of ethical hacking is something that is desirable in our jurisdictions. And what they mean by ethical hacking is that someone gains unauthorized access to your data or to your systems for the purpose of proving vulnerabilities. Unauthorized access. Now, in a situation like that, the first thing is to understand that the fact that the access is unauthorized means that this person is gaining access and is able to look at, review, save, disseminate data that the state has a responsibility to protect. The question is, when an individual gains unauthorized access, who is to say what they've been looking at? Who is to be able to control what they have access to? And the very responsibility of the state to provide citizens individual data becomes compromised. Now, I want us to understand that there's a difference between this and what has been commonly known to come to be called as bug bounty programs. These bug bounty programs, large corporations have been a part of. They've launched these programs, companies like Microsoft and others, Yahoo and others have launched these programs, inviting people to access their systems and show vulnerabilities. And really it's a way of, and they reward them. They say, I'm gonna give you access, you try to break this thing. You try to show where the vulnerabilities are. But again, in cases like that, the fact that it is a structured program with constraints takes you out of the realm of criminality. I have said this before. The government of Barbados, like most other jurisdictions, cannot contemplate a reality in which we allow unauthorized access. That would make any legislation to protect systems and data moot and irrelevant. So I wanted to clarify that and also to give the assurance that the notion that there's this widespread ethical hacking that countries have allowed, private corporations can do what they want. Private corporations can let ethical hackers run all through their information. They will have to answer to the regulations of that state. But as a government, we would be negligent in our responsibility to the people of Barbados to allow unauthorized access wherein a person gains access to our systems and our data and your data and then says, well, I'll show you how to fix this, or I'll give you back your information if you pay me a sum of money or if you let people know that I was the one who broke it. I do not see how, in the context in which we are trying to maintain order and people's privacy and people's security, we can allow that to happen. And just to reiterate that this notion that countries all over the world are doing it is incorrect. There was as well a comment related to critical infrastructure and that critical infrastructure systems should be listed in the legislation. I do believe that the systems that are contemplated with respect to Clause 12 are itemized in some measure in the schedule, and critical infrastructure systems are all represented except for those related to hospitality. A colleague of mine did raise this notion and whether, as a tourism-dependent economy, critical infrastructure that is related to hospitality might be itemized and included. And of course, specifying the nature of the critical infrastructure is something that one cannot object to. I mean, if the reason that it is able to be amended by ministerial order is that we expect that the identification of the critical infrastructure will change. We will set up more different kinds of critical infrastructure. We're talking about things like hospitals, cell towers, and so on, and that will change. There's also the question that came up of, and so let me clarify that it is itemized, it is specified, but also that we can't consider this an exhaustive list because infrastructure itself, technology infrastructure, telecommunications infrastructure, by its very nature is changing. And there's infrastructure that will exist next year that doesn't exist now. And so that can be amended at such time as is necessary. There are those who have also raised the question of placing a positive obligation on persons or companies who are in control of critical infrastructure and systems to put certain measures in place. And actually that is also contemplated under the convention. It is also capable of being included in other aspects of law. And it is the idea that if you are a telecommunications company, a private utility, you have a responsibility to secure the infrastructure that services the people of the country. And there can be no objection to that. I don't know to what extent you, in making your recommendations for any amendments, may want to consider that, but it is contemplated under the convention, and it is capable of being introduced in other areas of law as well. I also want to respond to a comment on Clause 21 that relates to cyber terrorism, and there is a notion that the provision for cyber terrorism is not sufficiently broad, which is a bit of a surprising observation, because it doesn't include solicitation or what the commenter calls preparatory acts. Let me say this, a thing does not have to have a particular label, I would say, in order to reach the level of criminality. So the guidance, not only Budapest Convention on Terrorism, criminalizes, by the very definition of terrorism, the preparatory acts that are involved. And there are lots of jurisdictions that have separate terrorism legislation and in fact have not included this provision at all in their legislation. So I say that to say that I wouldn't be too concerned that we miss or we are unable to prosecute an act of cyber terrorism because we don't explicitly use the language preparatory acts, but that is contemplated in our definitions of what constitutes terrorism. Now, to come to part 3, which relates to investigation and enforcement. Again, there was a concern raised, and I think that it may reflect a less than thorough understanding of what these clauses relate to. Now, there was a concern raised that these clauses 26 to 28, but in particular clause 26, allows the state to intercept data in real time. Under this provision, the state cannot intercept data in real time. We deliberately did not include it in our own legislation, even though other countries who have worked with the Council of Europe and who are signatory to the convention have done so. And we did it specifically because we thought that it might trespass too far with respect to persons' liberties. This relates only to the production of data that is specified. So under this clause, you are saying exactly what you're asking for to be produced. And in fact, this provision is widely considered to be so non-intrusive. It actually proves to be perhaps the least problematic provision for most cooperating jurisdictions, because it relates to just the production of data that you say, that you specify, that you're requesting. This clause does not allow, nor does it elsewhere in the bill allow the interception of data in real time. I have to say too that the search and seizure provisions under this legislation are fully in keeping, not just with what currently obtains with all other legislation in Barbados, but the Council of Europe is doing a study of how countries authorize search and seizure under cybercrime legislation, and have found that 95% operate on this system of sworn affidavits and the system that is outlined in this legislation. That is the system that is used. And so I wanted to clarify that the search and seizure provisions under this legislation are not at odds either with what is currently done to be able to obtain a warrant, to be able to have sworn affidavits and so on for access to certain kinds of information in other kinds of crimes. But it is also in keeping with what the over 73 countries that are signatory also have as their provisions. Now, I also want to clarify something with respect to clause 27 and 28 on data preservation. To say that, and perhaps I should reference exactly what was the difficulty. So data preservation is exactly as it sounds. It relates to keeping information exactly as it was, as it exists at a certain time. It does not relate to, and so the comment, let me just make reference to the objection that was raised. The observation that was made on clause 28. Clause 28 relates to the preservation of data for criminal proceedings. So what that means is that there's information that you want to be able to further review, analyze, prosecute. You want to be able to have access to it in the form in which it existed at the time. And the Commissioner of Police or any other officer designated by him in writing may make an ex parte application for a preservation order to a judge or a magistrate where computer data, including traffic data, stored in a computer system is required for the purposes of a criminal investigation, and B, there are grounds to believe that the computer data stored in a computer system is particularly vulnerable to loss or modification. There are grounds to believe that the computer data is particularly vulnerable to loss or modification. And the comment is that in the legislation, there's no discussion of the conditions and safeguards for adequate protection of liberties when collecting and storing data in criminal proceedings, including chain of custody. Chain of custody does not enter here because nothing is moving. There's no chain. All this is saying is if, for example, there's data that is likely to be the subject of criminal proceeding and it is being held in the systems of a telecommunications company, is being held on Dr. Springer's computer, is being held on somebody's flash drive. All I'm asking for is that the data not be destroyed. That's all. So for example, there's some companies or businesses that may have a system of automatically getting rid of certain stored data. So by asking that the data be preserved, I'm saying, look, don't get rid of this. I'm stopping you from getting rid of it. I'm not taking it anywhere. And in fact, data preservation is usually a fundamental first step. So what happens is you ask for the data to be preserved so that you can go and get a warrant to be able to further examine the data. The truth is that our level of authorization simply to keep data in place is a higher level of authorization than there is for most countries. In fact, most countries ask for the data to be preserved to give them time to get a warrant. Here we are asking for a warrant to preserve the data, which is actually an extremely cautious approach to the matter of data preservation. In fact, from our review in 40 years of data preservation in the US, these days one doesn't even have to be a lawyer to make a preservation request. It is simply asking, and this is in that legislation, not in ours, it is simply asking that data not be destroyed. It freezes the data in the hands of the provider. It doesn't freeze the data in the hands of the government. That is flatly wrong, that suggestion. All it is failing to destroy, and there are no chain of custody considerations because the data has not moved. As an overall comment, I just want to say on the matter of search and seizure that police officers in this legislation, as with all other legislation, must act within the parameters of the existing warrant. And that is true whether it is a cybercrime or whether it is a physical crime. So I want to address the notion that somehow the fact of this being cybercrime means that all of a sudden officers of the law are at liberty or can take all kinds of liberties with people's own privacy and so on. Whatever would obtain in a warrant where you are the target of an investigation, I have a warrant that entitles me to go into your home, to go under your bed, to go into your pig pen, to go into your garage. Whatever is contemplated, whatever is outlined in the warrant is all an officer can have access to. Now, I want to come now, after those clarifications, to perhaps the part of my presentation that you may find most interesting. I hope that you find it interesting. And it is to say this. Notwithstanding that, clearly I believe that this legislation is necessary. It was deemed necessary as far back as 2005 with the Computer Misuse Act. There are other pieces of legislation that address these matters in other ways. As the law stood prior to the drafting of the Cybercrime Bill, the crime of criminal libel was a part of the law of Barbados. And most of you in here would know about Section 34 of the Defamation Act. In that same section, the defenses applicable to civil defamation were made to also apply to criminal libel. The idea of criminal libel is not new. It is being brought into this legislation from a place where it already existed. When the Cybercrime Bill was drafted, criminal libel was specifically abolished, and you'll note that in the schedule to the bill. But we realize that some defamations can be extremely egregious, and can be so much so that they go beyond compensation for civil defamation. And I made this point earlier in my presentation of the bill in the House. We also have to consider that bringing a civil case against a person requires resources. It requires resources, and we have to be, as a state, we have to put ourselves in a position to be able to defend all people. Those two women in the US, if they had not had the full might of the opposing party and the outrage of other citizens behind them, they would have just been another story of two people whose lives had been destroyed by defamation or by criminal libel, or by libel. And so I want us to understand that the law has to be made for all people, and it has to protect all people. And simply preserving this area of legislation in the domain of the civil does not do that. Many of us speak every day to Barbadians who feel aggrieved by something for which they can't pursue litigation or take any civil action because they simply don't have the resources. And so I think it's important for us to understand that raising this or bringing this to the criminal space, first of all, is not new, because criminal libel existed before, and also is important to be able to protect people, but further, the scale of the damage and injury can be so great that in my estimation and the estimation of many other countries, it elevates it to the realm of the criminal. The other thing to note, and I'm sure that you've had this discussion among yourselves before, Clause 19.3 of the Cybercrime Bill, which I'll spend a little time on, purported to create a replacement for criminal libel, but sought, in its framing, to protect freedom of speech by giving a person the right to put forward any of the defenses mentioned in Clause 19.5. And I want us to be clear that these defenses matter and that we should turn our attention and the attention of the public to these defenses under 19.5. If a person is charged under 19.3 and can prove that he was speaking the truth, he will have, as we all know, a cast iron defense. And so, truth as the ultimate defense is one that I don't want us to lose sight of, because I don't want us to alarm individuals with the notion that these provisions go against freedom of speech. In fact, they aim to protect freedom of speech in the context of criminal libel by the defenses that you've reviewed and that the bill lists at 19.5. As I've mentioned before, the essence of the offense in section 19.3 is the intentional use of a computer to disseminate information that is false. And so I reiterate the intentionality that must obtain, as well as the falsehood. But I will also say this. I have myself reflected and listened to what has been raised, in particular about sections 19 and 20, malicious communication and cyberbullying. And I think the first thing to realize, Mr. Chairman and colleagues, is that I think we have to be careful that we are able to have precision and surety with respect to legislation. I think that we have to be tight, precise, and clear in our meaning so that if these matters do reach the judicial system, that system and that process also has clarity and that we can know that prosecutions are likely to succeed if they reach that point. And it is for that reason that I think that to the extent that we can remove anything that may be framed or considered vague, that we should do so. And so I want to offer for your consideration with respect to 19.3. And I would love to have your feedback on this because these are my reflections and based on some conversation with colleagues, but of course I would love to hear your thoughts. I think an amendment to clause 19.3 that deletes the words not caring whether they are true or false and substitutes the words that are false and causes or is likely to cause a person humiliation, embarrassment, or reputational injury is guilty of an offense, and so on. And so in that way, I would delete the words ridicule and contempt. And if you don't get tired of my voice, I could go on later to explain why I've opted to delete certain words or suggest that we delete certain words.
Minister, you can repeat what you said there? To delete.
So I would say, I would offer that we delete the words, this is 19.3, the words not caring whether they are true or false, and substitute the words that are false. Because the injury, the crime, the act, in my mind, relates to the falsehood or the falseness, if I were to coin a delicate term, of the utterance or of the image or of the statement, rather than the truth, because that is a far more, perhaps a broader set of considerations. So I would say delete the words not caring whether they are true or false and substitute the words that are false and causes or is likely to cause a person humiliation, embarrassment, or reputational injury is guilty of an offense. And that would have us, if you accept, delete the words ridicule and contempt.
Minister, again, to delete ridicule
and
contempt,
mm-hmm.
And you said to substitute reputational.
I can share the language, but
and substitute reputational injury, you said?
So perhaps I should read. So take out not caring whether they are true or false and substitute that are false. And following on, and causes or is likely to cause a person humiliation, embarrassment, or reputational injury is guilty of an offense. And therefore, if my reading is correct, it would mean the deletion then of the words ridicule and contempt. Now, clause 20, with respect to cyberbullying, I also think has some scope for us to be more precise. And I think precision strengthens the legislation. So in respect of clause 21, cyberbullying, I would rewrite paragraph B as follows. For the purpose of causing danger, embarrassment, injury, humiliation, intimidation, hatred, anxiety, or causes substantial emotional distress to that person. In so doing, I have deleted the words annoyance, inconvenience, obstruction, and insult. And I have a method to my characterization of those words. I think that the ones that I am offering for your consideration that we keep are either able to be defined in law and or have their definition elsewhere in law. And so I feel comfortable, and I'll tell you that, you know, I feel that if we separate the fact that I am the proponent of this legislation, I think also the fact that I am a non-lawyer who is myself understanding and perhaps bringing the perspective of a person who may feel uncomfortable with certain of these words and definitions. Now, I have to say that it is my understanding, and I think we have a responsibility, and you in the room who are lawyers have a responsibility to clarify that the meaning of a word in our day-to-day lives need not necessarily align with the meaning of that word in law. And that often these words have accepted definitions in law, but also that these words have an evidentiary requirement. And when I say these words have an evidentiary requirement, what I mean is that you must prove through evidence in the court what you take these words to mean. If I say that something has caused me injury, then there's an evidentiary requirement associated with that word, injury. And so I think it is also our responsibility for those who may be taking some of these definitions in the lay understanding to be able to confirm and to be able to reiterate that these words have a legal understanding and a legal definition and an evidentiary requirement that must be made in court. My other amendments, Chair, really just have to do with the organization of sections with respect to, for example, the word intimidate at section 19.4 may be a bit out of place because of where it needs to be defined. It may need to be defined in a different place. That is something that I'm sure that those who are working on the drafting would clean up. But substantively, I do feel, one, that it is important that we are able to proceed with the protections offered by this legislation, but two, that we're also able to present this legislation and preserve this legislation as something that Barbadians can feel protected by and not persecuted by. And so to the extent that we have the capacity to do that with amendments to the language, but we also have the capacity to improve the precision and the strength of the legislation, then I offer for your consideration those amendments. Thank you.
Thank Thank you, Minister. We will now allow members to engage you on anything that you have put forward or said, or proposed amendments you have just put forward.
Sorry, if I may just take 30 more seconds as I look at my notes. There's one other thing that, again, this is the non-lawyer in me, seeking to give people some comfort. I know that the use of the word liable with respect to fines and terms of confinement is understood in law to mean that it is up to, so that $70,000 or 7 years in prison, it is understood. However, if it would not be redundant, I think it would go a long way to include in the language up to, because in the common understanding among Barbadian people, people think that a particular offense automatically, I see people smiling, I'm assuming that you all had this conversation already, automatically attracts. Well,
No,
I mean,
no, the Interpretation Act of Barbados speaks to that. So all of our legislation has a maximum fine and or maximum term of imprisonment. But obviously within that, there's judicial discretion. So, and yeah, we went through that this morning. So even though it generally speaking says 70,000 or 7 years imprisonment or both, a judge may say, I'm gonna just reprimand you and discharge you. I ain't not fining you, I ain't not jailing you. And therefore judicial discretion must be allowed.
I'm aware.
So all of our laws, all of our legislative, provisions that penalize have it like that.
Yeah, I'm
the drafter.
Yeah, I'm aware of that.
So
but I'm also aware. I'm also aware that some, with respect to data privacy, data protection, and cybercrime legislation, some jurisdictions have opted to include the language of up to, just because it relates to things like speech, things that people do every day, and they have found that in those cases, people want to have a sense of assurance with respect to the severity of the fine. So I put it on the table, being fully aware of the Interpretation Act and fully aware that this is a cap, in a manner of speaking, but I also wanted to put that forward because we understand that there is a certain concern about the level of the fines and the terms of imprisonment. So with that, I'm finished. It is not foreign to our sensibilities to have the notion of criminal libel, and I would not want anyone listening to this conversation to suggest that bringing this to the level of criminal proceedings is new. It is simply taking the notion of criminal libel, preserving it in this law, but then allowing for defenses at 19.5 that preserve a person's freedom of speech. So let's not suggest that bringing these matters to the level of criminal prosecution is new. But I also offered that one of the reasons I believe that we must use the parts of the law available to us is that civil proceedings require resources, require means. I can't tell you, I grew up in a village in Haggett Hall. And it is not to say, you talk about how hatred has existed forever. It is not to say that people have not been aggrieved, poor people have not been aggrieved before, but if you are a poor person who is aggrieved by something somebody has said about you, you are very little able to be able to pursue that person, to get any restitution in civil proceedings. Why? Because I cannot afford a lawyer. I cannot afford the time from work or the daycare to show up in court all the time. There is an extent to which we as the state have to stand in the breach for those people whom you and I represent, Honorable Member, who cannot so do for themselves.
Okay.
I, I don't think that these matters can be addressed in the realm of civil law. I think, first of all, that what the world has been doing is setting up what is essentially a criminal framework for these matters. And the only way it works is if we, as in states across the world, jointly consider applicable criminal prosecution in these matters. So, for example, one of the things that cause people to receive no justice for offenses against them was the fact that we did not have this cross-border jurisdiction in civil matters, so that those who tried to bring action, civil action against people who may have been in, I shouldn't say Serbia a lot, Luxembourg or Croatia or the US, those who tried to bring action, civil action, were not able to proceed because there was nothing that allowed them to reach across those borders, notwithstanding that the crime was borderless, to be able to pursue that. And so for many reasons, for the reasons that I've already outlined, because of the fact that civil pursuit did not allow you to go across borders and gather evidence from other jurisdictions, it simply is not possible to address these matters in that realm. There is an extent to which there's public damage as well that is caused by these offenses. And that's another reason why I believe that civil pursuit does not serve completely. I mean, when you have a case where, or a scenario or a situation where attacks made or harm done in this realm continue unchecked, that contributes to a certain sense of disorder and absence of governance. And so I say that to suggest that there is apart from the injury to the person, there's an injury, there's damage to the society when these things are allowed to stand. I really encourage Barbadians to not be sidetracked by the overemphasis on a particular area, and to be reminded that this legislation is one about protecting people's information. It is about protecting children in an online environment. It is about making it so that what happened to those two women in the context of the US election, where they lost their reputations, their safety, their work, their homes, that is not something that takes over. That is not something that is done as a matter of course, that people feel that there are not consequences for the utterances that they make. There are consequences. There have always been consequences for the ways in which we speak about people, the ways in which we gain access. You know, the truth is that a lot of what is covered in this legislation, it is akin to gaining unlawful access to a person's home. Being able to break into the systems of the state where there's information related to an individual. That is what Barbadians are insisting on. They're insisting on the kind of data protection that this legislation allows. And that is why I said at the outset that pausing this bill to have these conversations allows us to reflect on what we want. Bajans have said very clearly that they want this kind of protection. We all know, I dare say in this room, people whose lives have been very adversely affected in Barbados by the kinds of actions that this legislation criminalizes. So I do want us to step back and consider this thing in its entirety, to be able to understand that this is primarily about protecting individuals who can ill afford to protect themselves. Most of us in here don't need the state to represent us if somebody says something about us that cannot be supported or that does damage to us. I keep hearing thrown around this room this afternoon this notion that I am speaking for the people outside. Look, this legislation is speaking for the people outside. This legislation is about making sure that even in cases where a person does not have the wherewithal, the resources to defend against these kinds of attacks, that the state is going to step in on their behalf. And so I do believe that we've listened. I certainly have in my own reflection, and what you've heard today is a result of my own reflection, to what might have given people some pause. But I think that this country will be the better for passing this legislation, which, as you have highlighted, Senator Nichols, really is a revised and renewed version of legislation that has existed before or has existed in other places.